First of all, welcome everyone. Thank you so much for spending time with us this afternoon. Thank you, Stephen, for your time. So this is the inaugural webinar joined with the United States Patent and Trademark Office, and it's the first one in a series of 4 that we currently have planned. Thank you, Connie and Mei Ling and Dee of the Rutgers New Brunswick Libraries and Innovation Ventures co-hosting this event. And today's speaker is Stephen Yanchuk, but Dee will do the introduction a little bit later. So first, I would like to do a super brief plug-in for Innovation Ventures, which is the team at the university that's responsible for patenting and commercialization activities of all of the innovation that comes out of Rutgers labs and, minds of our researchers, et cetera. The mission of our team is to partner with the Rutgers community to encourage deliberate innovation, protect and leverage Rutgers intellectual property, foster collaboration with industry, and enable entrepreneurship. We are comprised of 4 functional units: intellectual property, licensing, new ventures, finance and compliance. Intellectual property teams focuses on all processes related to protecting the intellectual property, working with outside counsel, working with the USPTO in obtaining patents or copyright or trademarks for our innovations. Licensing team does the evaluation of innovations and sort of coordinating all of these efforts and negotiation of agreements with outside prospective industry partners that take the innovation onto the next level. New Ventures provides a whole suite of services to support entrepreneurs within the Rutgers community, spin out companies, introductions to investors, et cetera. They also manage our commercialization fund that has 2 sort of parts to it, Tech Advance and Health Advance. And finance and compliance team does exactly that: agreement, compliance, alliance management, paying bills, distributing revenue. And just wanted to point out that innovation at Rutgers has a long and rich history. We have several, many products actually, that are in the marketplace and serve the public and benefit the public in a great way. The most recent one being the RUCDR Infinity Biologics, which was the first coronavirus saliva-based test. And we have a whole variety. This is a very small sampling of products that we have in the marketplace. And just to do a little bit of bragging on specifically the last fiscal year, when we were working from home, working very hard in partnership with all of our innovators within the Rutgers community, the licensing revenue was a record revenue year of $42.6 million. And we managed close to 1,200 active technologies. We filed patents, we had patents issued US and worldwide. The one aspect where we need to grow and do better is new invention disclosures. So we're hoping that everyone who is listening will spread the word, think of us, think of the USPTO, come to us first if you're a Rutgers employee or a student, so that we can work with you to get patents filed and your invention commercialized for the greater public good. And without further ado, I'm going to turn it over to Dee for the introduction. But just before I pass it on, I'm going to mention sort of the rules of engagement today. We're going to have the speaker, Stephen, who, as I said, Dee will introduce. And please hold your questions until the end. You can type them in the chat, but we'll have a 10 to 15 minute Q&A at the end. If you need something answered urgently, we will jot it down, follow up by email, however you want your question answered. Okay, Dee, back to you.
Thanks so much, Tatiana. I'm Dee Magnoni. As Mei Ling said, I'm the Associate University Librarian of New Brunswick Libraries. We have 7 libraries, special collections, and university archives in New Brunswick, but I am here to talk about the Library of Science and Medicine today. which you can see on the slide that Tatiana has included. The Library of Science and Medicine is on the Bush campus, and it's one of 83 USPTO patent and trademark resources centers, PTRCs, in the United States. The PTRC representative is an information expert trained on how to use search tools to access patent and trademark information. The human touch that no webpage or legal book can provide can help professors, student inventors, and local inventors find the information they need to protect their intellectual property. So, introducing Stephen Yanchuk. After more than a decade of examining fuel cell and battery patents in the 1720s art unit and becoming a primary examiner in the U.S. Patent and Trademark Office, Stephen Yanchuk has been selected to participate in the Eastern Regional Outreach Office of the USPTO as a special advisor. The task and efforts support the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO. One major component of the outreach is to engage with the USPTO's East Coast stakeholders, us. Focusing on the region and actively engaging with the community, Mr. Yanchuk ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystems of industries and stakeholders. So, Stephen, I am so happy that you're here with us today. I visited the USPTO once many years ago, and for everyone on the call, you should visit. It's a really awesome place. But with that, Stephen, I will turn it over to you.
Well, thank you so much for that introduction. Before we get into the slide deck today, I kind of wanted to, just talk a little bit, get you guys to know me a little bit, and kind of talk about the PTRCs and what's going on with Rutgers. I just had the ability to sit in front of young students today, and I'm going to use some of their Q&A that they gave with the thoughts that are going around in my head to kind of have this opening that talks about the PTRCs are really important because when you have that idea, you may want to check to see if it exists, right? Because a lot of engineers and scientists know that 5 minutes in the library can save you 5 years in the lab. So it's a great resource to see if somebody's already done that. I'm sure Tatiana's group at the IP team would value you coming to them and asking, is this an idea that you would want to pursue? One of the kids earlier today asked about inventing and like getting disclosures and going through the school, and they were kind of afraid, right? Because they wanted to, it's their idea. It's like the reason why you utilize somebody like Tatiana at Rutgers, you have to, you are kind of under that contract, but also the communication with the patent office is a really we always kind of do say that you should have counsel. You should talk to people. That way you can keep doing what you're meant to do, right? You invent. You are an engineer, a scientist, and an innovator. And so when you do that, you can focus on advancing your innovations and your specifics, holding ideas back in general. And this is going to lead into the whole conversation that we're having today. Is that when you disclose those information, right, and you start that process of applying for patents, you can then move on because now you've already said, like, I have rights to this idea, this concept today, if nobody else has already invented it. And what that does is it allows you to keep expanding upon it, right? And so then you have that next idea that builds upon the previous idea, right? And then you can seek patent protection for that as well. And the whole space is getting better because now people can read what you've done and then they can maybe see it in a different way, build upon it. And so with that, I'm going to kind of jump into it. I hope that didn't sound like a soapbox and that it was interesting insights from Stephen Yanchuk from the Patent Office. All right. We're going to briefly go over the different types of intellectual property. And reasons that you would want to have all four of these is, imagine that your company or your idea is a briefcase, a suitcase of intellectual property papers. You would need a combination of all of these in order to secure your brand and your invention and your protections. So patents, trademarks, copyrights, and trade secrets. Trade secrets, we're not discussing that today. Copyrights is as soon as you put it down on paper, you have a copyright for it. You can register that copyright, and it awards you more protections. Trademarks is for your brand, and your brand is important. I'm sure, as most people have become well aware of social media, that branding is everything. Now, but it just allows you and the consumer to have kind of a relationship around the way you present your information, your brand image, and your product quality, your product, your level of quality is protected through registering your trademark. But today we're here to talk about patents, so let's jump into it with first creating the structure of what is a patent. So a patent is something that excludes others from encroaching inside of your space. It's a limited term, and the reason why we have it as a limited term is because one, it allows other people after the 20 years to start using the invention. It basically gives you a leg up in the race, if you will, in that field of endeavor. But it also inspires inventors to keep innovating in the space that they're already an expert in. If you had the best patent in the world on an industry, and basically nobody could invent and innovate inside of that industry without your say-so for the remainder of time, then it would be stifling to innovation. And that's not what the Patent Office is focused on doing. The Patent Office is secured from the United States Constitution. Here, we'll stick on this slide for a little bit. And what that does is it allows you to own that property right. You own your patent, and you can license it, you can sell it, you can trade it. And it also allows what you guys have with Tatiana's group, where you can innovate and then they can work out the business aspect of it. I'm not super abreast to how the contract works for you guys, but before the Constitution and the trademark existed, think about if there was no patent protections that were able to be granted, right? Innovation would be stifled, right? You wouldn't reveal what your invention is because somebody who has a bigger business than you would just steal your idea and there'd be no repercussions. One of the first structures that came into place was, royalty, noblemen, and the states owning the rights of innovators and inventors. And that's not that great for innovation either, because there's not that personal level of motivation, right? You can financially benefit from your own invention. And it's protected in the United States. Why get a patent? To gain entry into and deter others from a market, allows you to sell your product and keep your competitors from infringing in that specific thing. Now, they can innovate around your product. They can create a new product. But it gives you that leg up into the space. And depending on how innovative your idea is and how new, you get more scope, because we'll get into how we assess allowability of a patent here in a little bit. But it allows you to create revenue. And oftentimes you'll hear stories of an inventor being in a space doing research, and then he invents something completely different. Right? I think Velcro is one of the inventions that comes to mind. And by getting that patent and pursuing that technology, it can help fund other research, other projects that are beneficial, right? So to create revenue. The types of patents is utility, design, and plant. Chances are most of you are going to be going after utility patents, because design is really the ornamentation aspects. So that's going to be, I think, some of the biggest cases right now that are in the news are about cell phone design cases, the beveled edges. I mean, they do feel different. They feel nice as a user. You appreciate that. Plants, you really would need to be in the horticulture field for that. And we have other lectures that are about that. They're very specialized plant patent lectures, because you need a lot of expertise for that. And then utility patents. That's what we're here to talk about today. Process, machines, articles of manufacture, or compositions of matter. So before we get into what a patent, like how you disclose a patent, the different parts of a patent, things to just kind of be aware of. Just because it's your idea, it is good to have a little bit of restraint, right? Don't post on social media about your idea. Don't sell the product that you're inventing. Don't write it in a newspaper, right? really, when you have an idea, you think that it's worth pursuing. As Tatiana said, go to her, fill out that form. I'm not too familiar with how Rutgers does that, but there's no harm in internally filling out the paperwork. I'm pretty sure, at least. I don't quite know you guys. That's just an asterisk, I guess, for everything that I do when I talk about Tatiana. It's just really fill out those forms and then work with her team. When we work with the Boy Scouts of America on the Inventing Merit Badge, one of the requirements is that they innovate on an idea. And it's not necessarily about creating something brand new, but really starting those steps. So maybe the first time you file a form or you seek to see if something is innovative, right? You get a little bit more exposure into the patent process system. And that exposure then allows you to kind of get it a little bit more. Like, well, what is an innovative aspect that can get a patent, right? And you've seen maybe a little bit more exposure to what patents are. And so the next time you're filing a form, you get a little bit further in that process. And then eventually you can file your own patent because you're thinking in the way of, well, what is allowable subject matter? We're going to get kind of tap into those throughout the different courses that we have from the USPTO. So when you should file, we are first inventor to file system. So when you file, you call dibs on like today. If you were to file your provisional or non-provisional patent, you're like, I got it. Before that, well, there's no way to prove that you invented it. Before you really talk at all, you're going to want to file for international protections. And then in the U.S., you do have 1 year from a public disclosure. But if you're looking for eventually like manufacturing purposes, like if you manufacture in another country, you would want patent protection there. So you would want to file and disclose with the USPTO. So the essence, you have a new idea. Great. You can file an optional provisional application. The purpose of this, and we'll get into this in a little bit, but then there's a non-provisional and then you get a patent. It's easy, right? 4-step process. Before we get into the different applications, one thing that I've been aware of is a prior art search. Right? Prior art is, you say that you've invented this, but, did you? Are you the first person to come up with this idea? And so you can conduct keyword searches, look inside of your field of endeavor. We have a classification system at the USPTO, so you can find out what your patent is going to be classified in and kind of search through that specific field of endeavor. I'm in fuel cells and batteries, so there's a very specific set of codes, and then all battery and fuel cells are within that code. So if you were innovating in that field, you would want to kind of flip through with your specific idea. Prior art is not just patents, it goes all the way to foreign patents. And so as an examiner, I will do keyword searches through abstracts within that field of endeavor, like within those classification codes, journals and magazine articles, books, websites, and scientific papers. Everything's fair game. If it was published or invented prior, it's fair game. Also, your dissertations, if you're in the PhD program, if it's not closed doors and where everybody is filing an NDA prior to your discussion, that can be used against your filing date. So you do have a year from that dissertation. It's just be aware of that. If you're planning on filing, probably file before your dissertation, just to be safe. And you can file a provisional. So a provisional basically puts the USPTO on notice that you have an idea that's coming. You're calling dibs to that time, that date and time. You don't need a claim. You just need a written disclosure, and you get 1 year. And so that 1 year allows you to work on your patent application. You've already called dibs. You've already disclosed it with the USPTO. We know that your time is on that date. So if you're looking for investors, marketability, doing those types of analysis, you have a year to start that conducting of that. The non-provisional is what will be picked up by an examiner and reviewed for patentability. It needs at least one claim, and that's going to set the metes and bounds of what your inventive concept is. And this is really where having that outside counsel kind of help you. And in this case, Tatiana has said that you go through them to define what those claims are. And it's a skill set in and of itself to draft claims, because there's a way in which the communication between the examiner and the lawyer or patent agent, it's a skill set. It really, it's weird. Patent claims, I don't know if you guys have signed up for that course, but it's very interesting. Provisional utility applications. You want to have your specification that clearly describes your invention in compliance with 35 USC 112. So for you guys, I believe that you're students and faculty. What that means is, did you reveal what your aha moment is, right? If you are innovating and you're talking about the specifics of a porosity in a layer, well, how'd you get that porosity? And why does that specific porosity matter in the grand scheme of things? If it's a specific range of a porosity layer, or maybe it's a composition of matter that you have some parts A, some parts B, right? Applying the scientific method. Well, what happens if you have too much A and not enough B, right? And producing that narrative inside of the patent will be an enabling written description, and it will communicate what your idea is. It'll set you up going forward. And of course, this is within what your counsel would like you to do. But the general basics of clearly communicating what your inventive concept is and allowing somebody to reproduce it through clear description will also help you in the longer run of things when you're working with a patent examiner, because that patent examiner will be able to pick up your invention, because they're shifting gears because they were just looking at another invention. All right, they were working on a previous application, and they pick up your case, and they're going to need to dive into understanding what your aha moment is, right? What should they go search for? And so that's the point of the 112. You'll need drawings in most cases, and then a filing fee and a covering sheet. So this is kind of for your resources. I believe I'm going to I send these over to you after, and then you'll distribute them to your lecture, or you can watch the recording. A provisional, it's not examined or published. You have 1 year time limit. It's only for utility patents, and it's a low-cost way to establish that date and time. Yeah, and the non-provisional is examined and has the potential to become a patent. Whatever field of endeavor you're in, go look up a patent. You'll see the different parts of a patent, and you'll get familiar with it. For me, I still remember going and looking at my very first non-patent literature, like a journal article. And it was really difficult to extract information the very first time I picked up an NPL. But then as you keep pushing through and you keep getting more exposure to Nature articles and other non-patent literature, you develop a way to extract information from those articles. And I'm sure a lot of you in your journey through science and engineering have already developed that skill set, and you're only getting more and more proficient with it. Patents is much the same way, where the layout of the patent allows you to have an idea of what the patent is before you pick it up. And you get proficient at reading and extracting information from patents because of the way that they're laid out. The title of the invention sets the framework of what you're in. The abstract is 150 words that allows you to get a brief overview. And then you get into the written description, and that's broken up into a couple of parts that lead you down that story of innovation. There's a background section that sets the stage, what's already been invented. And then that sets the framework for you to springboard off of what's already been invented to declare what you invented in your summary section. Then there's a highlighting of what your figures are, and then a detailed description. And this is where you get into the nuts and bolts, and really you're talking to other scientists with that written description. Prior to that, most anybody can pick up your application in your field that's studying and get a good sense of what you're going to be talking about. The specifics of talking about precursor materials and temperatures and process steps, that might not be as important to the broad general audience, but that's going to be found in your detailed description. And that's going to set the framework for what your claims rely upon for support in your 112 descriptions. So I left it up here. I kind of just described all of the next couple of slides because there's a pretty picture on that first one. So the overview of a description is the written description, how to make and use the invention. And again, it's establishing on the record to help somebody innovate this idea that you have, to be able to reproduce it and to create it. Because that's the quid pro quo between you and the patent office. You get 20 years of a monopoly on your aha moment, but in exchange, you have to share how to reproduce it. How would you use it? And that how to use it doesn't need to be super specific, but it needs to be specific enough so that way somebody has a good idea of what you're planning on using your invention for. Yeah, at least one specific embodiment. A lot of times people will have embodiment 1 and then how you create it. If there's an integral step to creating a specific product, as I was talking about, like porosity or material compositions, if there's something that gives you a specific outcome in that end product based on one material step, it should be explained, because that's going to provide support later for why your aha moment is patently distinct from a product that doesn't have that step, right? And you conclude with at least one claim. And a claim establishes the metes and bounds. This is the legal enforcement of your patent. Everything else sets the framework for the claim, and the claim is what would be litigated against in court. It's what's discussed in patent prosecution with your examiner. And it sets forth what are the structural or method limitations, what's important with this. You know, and I guess one of the trends that I see a fair bit as in my examination roles is the idea of nexus of features, right? So merely claiming that A and B exist in a bowl is not as important without having the context in the specification that A and B need to be in the bowl in this certain amount of concentrations or whatever it may be. And then why, what is the desired result? What is like the end material property that's different? And then how can you adjust things? What is your aha moment? What is that criticality in that step of mixing the specific elements A and B? Because it's not just about putting A and B in the mixture, it's about putting them in a specific way into the mixture. And your written description that explains that sets the framework for examination, which then produces clear metes and bounds to your intellectual property. It showcases that you had an understanding of that invention prior to you filing the claims. It's not just an idea where you believe, an idea that you have, like the precursors, it's like, I have this idea, I believe that these materials will succeed at that idea, and then I want to get this end result, right? Higher conductivity or stronger mechanical properties. You have to bring it into practice. And the examiner and people who will look at your application, we're not reproducing your work, but we've read so many of these patents that we understand the level of detail that other applications have put in there. And that's kind of without actually ever reproducing a result. I've looked at thousands of patents over my career, so I know what other people have disclosed as their processes for creating things. And so it's kind of your disclosures being almost mapped against what the examiner has already seen in their field. So again, going back to that idea of please take a look at patents in your field of endeavor, because it's going to set the framework for how to communicate an effective patent moving forward. So hurdles to patenting is having a novel description, right? And non-obvious over the prior art. So novel, of course, is the dream, right? It's never been thought of before. You created the internet, right? There's no prior art that exists, and you get to write your claims as broadly as you want. Outside of that, and I think the statistic of it is that there's 1% of truly novel inventions that are out there. However, just because you're not the first to market or the first to patent idea doesn't mean that you can't find an improvement that is allowable. And so the remainder of the cases are improvement patents, but they have to be non-obvious in your aha moment, what you're seeking to gain patentable coverage for. So a great example of that is if you have a layer and you're talking about an additive to increase the coefficient of thermal expansion, so that way the two layers bond together a little bit easier. You may be inventing in one specific field. You may be thinking, well, I want that to be for a battery. But the examiner may be like, well, I'm going to go outside because really what we're talking about is just bonding two material layers together. And so if it's obvious in metal bonding art and you're just bonding two metals together and you're using a coefficient of thermal expansion additive that's well known in this other field, well, it's not it's not a non-obvious improvement, because one, having ordinary skill in the art, somebody who is a professor or a student, while doing research to try to find the improvement for bonding two layers together in the field of batteries, would likely go outside of batteries alone and look at, well, I'm just bonding two metal layers together. What materials would I use? And if it's pretty readily available, then it's considered non-obvious and your examiner will write a rejection. And so that brings us into, what does a roadmap to a patent look like? And so you file your application with your disclosure, and your examiner then picks up that, they read it, they understand your art. And I guess a little bit about what an examiner is. So I said, in the introduction, it was said that I worked for over a decade in fuel cells and batteries, and that means that I only see fuel cells and batteries. Now, there's chemical, there's mechanical inside of that field, but I'm not looking at toothbrushes. If you filed a toothbrush, you would get an examiner that only looks at toothbrushes or devices with bristles. That person is an expert at being able to pick up your application, reading what your disclosure is, and then giving you the best prior art rejection and having that intellectual conversation with you about what your invention is. And they will write a rejection, an objection, and then you file back with an amendment or arguments. This is also a good time for every time there's a correspondence back and forth. On this roadmap, we see the roads intersect, and you have the opportunity to have an interview with your examiner. It's really a strong, powerful tool to communicate, because oftentimes at this point in time, everything's been written, right? Your examiner picked up an application that was written and wrote back to you. It's a good opportunity to connect with your examiner if you really don't think that you got a close prior art. If you think that the examiner has missed what you've invented, it's a good time to give them a call and be like, hey, my invention is not to a toothbrush, it's to a refrigerator. Why did you give me a rejection to a toothbrush? It's not that simple, but I think you get the idea. And then once you've kind of gotten as far as you can in that communication, you will either understand that the rejection is good and that prior art exists, and you won't be able to find allowable subject matter on your invention, in which case you would abandon your claim. And you can file another application on your next innovation and your next idea. If you don't agree with your examiner and you think that you still have a really strong case, you can appeal, and then that goes to the Board of Appeals. But if you find allowable subject matter, your examiner will issue an allowance and you get a patent, a pretty patent. So the roles of an examiner is to read and understand the application. And they are experts. They're trained in one specific field. Sometimes they move from one field to another, but for the most part, your examiner is educated in your field of research. They search for prior art and write clear rejections on the claims and all elements that are presented in the claims, all structural features that you've highlighted as being important. The examiner will write a rejection as to how that specific, all specific elements are taught in the prior art. And then it's to respond to office actions by clearly describing those findings. And they'll hold interviews as requested. You should interview. The role of the applicant is to file a complete application. There's a lot of tools and guidelines, and the resources lecture and event will kind of guide you through that. Disclose all well-known prior art. So it's your duty to say what your research led to. And again, that helps the examiner have a starting position. If you let the examiner know what your best prior art that you found is, one, it's your duty to do that legally, but then also it allows them to have to start their search in a specific manner to give you the best prosecution that you can get in a more timely manner. And to explain your position. This last bullet point here, make good faith changes to the application. That's talking about like the claim amendments. You can amend your claims. You can't add new information into the specification. Again, going to that concept that I said earlier about you have an idea, you believe you know the materials that will lead to a successful invention, and you believe that you're working to get a specific product quality at the end. That's not sufficient for a patent application. You need to have that missing nugget that connects the idea and the starting materials and the desirable end product. That's your duty to disclose, and you can't add it in later because you could have invented it in the time that it took for prosecution. So what do you need to disclose? You need to disclose enough for this quid pro quo with the United States government to be fulfilled on your side, right? The United States government gives you the ability to seek protection for your monopoly of ideas. In exchange, you reveal how your invention is done. And this allows for innovation to flourish. And so before we get into the Q&A, this slide is about the PCT. So there is no international patent. There is ways to get global coverage for intellectual property rights, but there is no one patent. If you get a U.S. patent, it protects products coming in and out of the United States. The general guidance is to have at a minimum patent coverage for where you plan to sell or work on your product, and then where it's manufactured and shipped. So, where does that product kind of touch ground? So that is all I got for you guys in terms of the formal process. I will stop sharing my screen and we can open this up for Q&A. I hope that was beneficial.
That was great. Thank you, Stephen. So we will give the audience a minute to come up with
Sure. So yeah, feel free to throw some questions in the chat while you guys are formulating those ideas and digesting all that information that you just got. I was told that there are some undergrads that are in the audience, and the patent office gig. I'll talk about that for just a brief moment. We're always applying. Right now, we have applications up for mechanical, chemical, and computer science engineers, but you can always apply even if you're not like a mechanical engineer. I was a material science engineer, and I applied under mechanical because there is no call for material science engineers. But then a supervisor will pick up your application, your interview or resume, and they'll put you where you'll be able to utilize your skills to the best. I still look at XRD claims, porosity, chemical compositions, everything that I learned in undergrad in some capacity, I still utilize. I don't necessarily do, differential equations. The really difficult math is not part of my,
All right, so we have first question from Benjamin. Please go ahead and mute yourself and ask away.
Hello, thank you for the presentation. Really appreciate it. So I am an undergraduate. I'm majoring in mechanical engineering and computer science. I'm really interested. So I'm wondering, you said that an application has to be non-obvious. in that like the changes, like you were saying, the changes between previous art would have to be non-obvious to someone in that field. I think I might be answering my own question here. But I guess that's just because the obvious changes would be that, okay, never mind. I think I've answered my own question here. Never mind. I just thought about it more. Apologies. I was going to ask why the obvious changes are like not allowed, but now I realize it's because like once you realize that someone in a different field could pursue that, it just makes sense. All right. Sorry about that.
No problem. Yeah.
We have another question in the chat. When do we have to disclose work through Rutgers? So all of the employees, staff, and students are covered by the patent policy that exists, and we currently have 2 patent policies in effect. We're unique among universities, maybe like that. My suggestion is that people disclose as early as possible, because then together we can come up with a strategy of when to file a patent application. What additional data should we have before we file a patent application to make sure that it's strong and has more of a chance of success of getting allowed and then subsequently getting commercialized. And my apologies, I actually forgot to introduce myself in the very beginning. So I'm Tatiana, and I'm the Associate Vice President for Innovation Ventures. And I am thrilled to be working with a great group of professionals that include licensing managers with a great variety of technical backgrounds. So when we receive a notice of invention, we work together with the researchers on deciding when to file a patent application. Sometimes we do it right away. Sometimes it's a rush. Sometimes we wait 6 months to a year to gather additional data so that it's stronger and we have more chances of getting over the potential non-obviousness rejections or novelty. So come to us early. Think of us as your advisors, essentially free advisors. We're here to provide service to the community, to answer questions, to work with you, to educate you, to support you. We have a commercialization fund which provides money for proof of concept studies. So come to us early. Frank, please unmute yourself and go ahead.
Thank you, Tatiana, and thank you so much, Stephen, for the presentation. I was just curious about, you mentioned that provisional patent was a more economic way of kind of holding your spot in the queue. Can you just talk about some of the costs associated with filing a non-provisional patent?
Right. So the costs for a patent, you may have heard, are in the thousands, tens of thousands. Those are not USPTO fees. USPTO fees are fairly nominal compared to what you would expect if you're in the private, going at it and getting legal help. So to the action, I believe it's $100 for a provisional to be filed. The non-provisionals, a couple $100. There's a search fee, and what Tatiana is talking about, it sounds like it's a great infrastructure to really help you advance and to get your feet wet in the patent system. You're all young, budding, engineers, entrepreneurs, innovators, and so seeing it firsthand, getting that experience is great. It sounds great. I would take advantage of it. I seriously would. Like, if you have an idea and you had the ability to say, like, is this something that you guys think is worth going after? If they said yes, I imagine that it'd be one heck of a roller coaster ride that you would learn a ton about.
Yes.
Good luck.
Thank you, Stephen, for support and the plug in there. Frank, to add a little bit more to what Stephen said, the USPTO fees, there are a couple of sort of different levels. One is the micro entity, which is the individual inventor, maybe a tiny company. I don't remember the details there. Then there's a small entity, which is not for profit or less than X number of employees. And then there's a large entity. So those are sort of the larger companies, and that's where things get a little bit more expensive. Rutgers is considered a small entity, so our fees are reasonable, but most of the patent applications that we file are fairly complex. And as Stephen said, it's rather rare these days where you have, truly novel something, you sort of have to weave your way in between what's already out there and distinguish yourself from the innovations that are already out there. And that takes several people putting their heads together and figuring out the best way to explain that to the patent office. So that's where we work with outside counsel. Rutgers pays all of the legal fees on behalf of our staff and students. And that's where the substantive cost usually happens. It's from the legal fees, from working with outside counsel. And to file a patent application, a provisional, every sort of university has different arrangements. Would say on average, $10,000 probably, if you take all of the legal fees into account, maybe a little bit less, 8,000. To file a non-provisional, if you file an international application, another 3,000 to 5,000. And then once you get into that back and forth with the patent examiner, where they potentially reject it, and you have to sort of explain yourself a couple of times. So on average, I'd say to get a US from filing to issuance is 25,000 based on my experience. And for international, it's a little bit more. And when you have a strong portfolio, you usually file a couple of applications. But there's a whole sort of strategy that's involved. And again, to Stephen's point, this is a great time for you to get involved and work with us. We have fellowships, internships program with our office. You can sort of get your feet wet that way as well. Okay, we have, I think, a couple more questions. Is Rutgers also named on the patent or just the individual's team? And the answer is, so if the innovation falls under the scope of the patent policy and you as the inventor are required to assign the rights to Rutgers, then Rutgers is named as the owner of that intellectual property, is the assignee, but you're always the named inventor on the patent application, even if Rutgers owns that. The other, and just I wanted to highlight, so under the patent policy, so not only does Rutgers pay the patenting fees and has the infrastructure where we would identify together with you the potential industry partner or help you set up a company, a spin-out company. We would also share the revenue with you as the inventor personally under the patent policy. So if and when we're successful in commercialization, there's a licensing revenue that comes into the university. Under the policies that exist right now, the innovator gets between 25 and 35% personally of whatever Rutgers gets. So hopefully that is something that would also further incentivize you, not just the excitement around innovating and being an entrepreneur, but also the prospective revenue. Are these resources also available to alum or only current student and faculty? So, I would say in certain cases they are available to alumni, but in order for us to do sort of the paying for the patenting, would require for the invention to be assigned to the university. It has to be, we pay for university-owned inventions. We can still provide some advice, so feel free to reach out to us and we'll do the best we can, but in terms of the robust support, that's for university-owned inventions. We have another question. Somebody raised their hand. I'm sorry, I'm worried about mispronouncing your name.
Hey, thanks for the such a nice talk, managing such a nice talk. So my question is, there are certain cases like, my supervisor, he once upon a time, he thought that the research that I am doing and planning that is patentable, but at the same time, he suddenly take abrupt retirement from the Rutgers. So is there any way I can go forward on behalf of my supervisor, and how tough it will be to patent on behalf of supervisor?
So We can talk to you to learn more about that. But in terms of filing for a patent, it has to be the inventor together with the owner. So we would need the inventor in the picture and cooperating in order for us to be able to do this and be successful. But feel free to reach out to us and give us the details. And if we can reach out to the inventor and work with them, even if they're no longer with the university, but they invented whatever they invented while they were at the university, that still falls under the policy.
Right. So at that time, my supervisor was in Rutgers, but right now he's no more affiliated to Rutgers. So
yeah, we would need the cooperation of the inventor.
Okay, thanks.
Connie, do you want to ask your question?
You want me to ask myself? Okay, question now is for Stephen. What is the probability of receiving a US patent? Talking about people sending in application after you guys doing all this examination. What's the final results? What is it for?
Right. So about 60%. So most patents that are filed do, or higher than 50%. So 60% become patents at some point, and then the other kind of metric with that is that 60 or 80% of patents that have interviews lead to allowances. So of the 60%, the majority of those are when an interview is conducted. And so I think that's an interesting. So when I said, like, please interview with your examiner, it's not just because, I want somebody to explain what the art is. It really is just because the numbers show that it's beneficial.
Okay, in addition to that question, based on your own experience, how many people, inventors, apply for patents and didn't go through a lawyer, just by the inventor itself?
So that's a really interesting question. The obviousness level is that one having ordinary skill in the art wouldn't find it as obvious, right? So me being in fuel cells and batteries really makes it not that open to somebody just walking down the street coming up with the greatest electrode chemical composition. That's just, it really doesn't happen. So it's a lot of teams and companies. It's a lot of Tesla, GM, Toyota, Samsung that I look at. So there are other fields of endeavor that you can come up with a patent by yourself. There are resources out there that will help you put your best foot forward. One of the people that I've had the opportunity to interact with, they had been inventing their whole life. They've worked with IP lawyers frequently. And then as they got kind of into the later stages of their life, they started doing it on their own. But that's because they had so much experience with it already. They had already worked with other people and patented other ideas. I just, like I said earlier, I don't know the ins and outs of the Rutgers thing with Tatiana, but the exposure that you get from just going through the efforts and getting the patent, getting that experience is going to make it easier later in life. Most inventors that have patents, I believe, I'd love to see the metrics of it, that you can, how many have just one invention versus how many that have 20 to 30 to 100. There are oftentimes many prolific inventors, and it's, I think, in part because they just figure out how the system works, and then they think in ways to be innovative and patentable, distinct, and then their research prospers because of it.
Thank you so much. And also the next question is for both of you, and Tiana and Stephen. What the percentage of patents are commercialized? Do you happen to know? We have a million patents, and everybody want to make money from the patents. But what is the percentage possibility, or whatever in your experience?
I think the statistics on that say it's 5 to 7% that ever become commercialized.
So at Rutgers, actually, we have 43% of our portfolio currently licensed, and we are working very hard to increase that number. But obviously, you know, that's not 43% of all technologies ever disclosed to us. It's 43% of currently active technologies. So we let go of things when we can't move them forward. We return them to researchers if they disagree with our decision to not move it forward. I just wanted to share with the audience just a sort of a bit of historical fact about the Bayh-Dole. So Bayh-Dole was a legislation in the 1980s that put together this framework, and the tech transfer offices at universities are essentially a result of that framework that was set in motion with that legislation. And previously, when there was federal funding to a university or a not-for-profit, the university would own the intellectual property that comes out of that research. So if somebody created a new, way to make batteries using the NSF funding, it was the federal government that would own that intellectual property, not Rutgers and not the inventor within the university individually. And there was not a whole lot of movement of that technology in terms of commercialization and making it available for the public use. But following the 1980 Bayh-Dole legislation, it really spurred sort of innovation within the academic space and the transfer of technologies from universities into the private industry and the use of it for the public benefit. It's been really tremendously successful. And so that's sort of where our mandate comes from. We are here to transfer technology from academia, from academic research into the public space. We're here to provide that service to you all as a community. We're here to work with the USPTO and to work with our industry partners.
Thank you. And next question also for Tatiana. If a faculty or staff or student has an invention that is not related to her work at Rutgers, for example, one person from dining service come to the PTRC asking about, he had the invention about hair dryer. He doesn't know if he can go just by himself because he's Rutgers, part of Rutgers person. Does the person still need to get approval from the university before applying a patent himself? Because he's Rutgers, but he said nothing to do with his cafeteria job, So just something. What is the mechanism to get approved, or just he can go on his own without go through Rutgers University?
So we from time to time get an inquiry like this from researchers, and we just have a brief conversation, acknowledge that, a hairdryer is probably not in the scope of employment of the cafeteria worker for the most part. And we provide a written statement that we agree that the university has no ownership in that intellectual property. And that piece of paper is something that I think facilitates, for example, the licensing that this individual may want to do in the future, or if they start a company and they do fundraising, that having that document in hand that's official from the university makes it that much easier. And in terms of the timeline of that, it's relatively quick turnaround.
So everybody at the Rutgers, affiliate with the Rutgers, if I have some invention come up, they should go through your office first.
Well, if they believe that it's so clear that it does not fall into the scope of the patent policy, they can go ahead on their own. Okay. We don't mandate that they come to us and get that clearance. But if it's anything exciting, I would say that they probably will want to have that paper in hand. So it's sort of a judgment call. But if it's anything that has to do with their employment, and especially if it's supported by the university resources, financial or facilities, they definitely have to disclose it to our office.
Okay, thank you. And also, Stephen, just want to let you know that I received a few emails just since you start this session that a few people couldn't make today, but they want to listen to your recording. So from people registered to now, at least 10 people, more than 10 people probably send a message that they want to watch the recording because the time conflict. One more question, Diana.
Okay, yep, one more question here. So international patents seem very daunting. How do you protect yourself? Stephen, do you want to?
Yeah, I mean, we've gotten into a global world, but with patents, you want to protect where you plan to sell, where you manufacture, and then in the United States. This is kind of the general rule of thumb. Yeah, I mean, Tatiana might have it's part of the plan. You might want to talk to her.
Yeah, we strategize together. We develop a strategy early on, which countries we're going to go into and why. We typically try to have a industry partner. Things get very expensive when you go and file internationally very quickly. You could be into up to $1 million very quickly with a decent sized portfolio. So we certainly want to have a partner to help us carry some of those costs. But we do it all the time. We have many international patent applications that we file and patents that get issued. So you're in good hands if you work with us.
Yeah, just kind of one other about the USPTO's role in patents, right? We are the first step, where we have examiners that are well educated to take a look at your invention and find allowability. At that point in time, it's not the USPTO's responsibility anymore. So the onus of protecting your patent falls on you, and also in terms of licensing or operating your patent. Again, that's on you. We don't provide infrastructure to help with licensing. We did prop up for COVID a little bit of help to help people find licensing patents to help just bolster innovation. But typically we do not do that. And so hearing a licensing rate of 40% is pretty remarkable. I haven't heard those numbers before. So, and there are a lot of people that are kind of in that position where, like, I have a patent, now what? How do I make my money? And it's like, that's not what the USPTO does. We are the first step to showing that an idea is allowable or not. And so,
So, Stephen, I have a question. If I invent something here in the US, can I go to another country and file an application there? Maybe, somewhere where it's cheaper?
Sure. Yeah. Yep. I mean, you could. You could file. Yeah. But then, if you don't have patent coverage for it in the United States, your intellectual property protections to go after somebody making and manufacturing and selling inside of the United States, it's not guaranteed. I don't believe, right?
I see. I thought that if you invent something, sorry, that was a tricky question.
It was a tricky question. Yeah.
I thought that if you invent something in the US, you have to file, the initial filing has to be in the US. Otherwise you have to get a foreign license filing to file. No?
That is a great question to ask counsel. I examine patents. I do fuel cells and batteries.
Okay. We'll take our time this weekend to review the MPEP and yeah.
Right. That is a good question. Like, if you invent in the United States, do you have to file inside of the United States in order to be able to file elsewhere? That is a nuanced question for sure.
Okay.
But
I'll let the others ask questions.
But my question, Tatiana, is very similar to what she's asking. I got a patron, and his patent, the same patent, was approved by USPTO. And he also, at the meantime, applied to other countries, but was rejected by that country. So he said, can he use the US patent approved to show to other countries, USPTO already approved, why you guys reject us? Because the other country used their own language, different, not English language, using some kind of language, some kind of reference, reject his application. Now he wants to go for appeal. So he said, can he use USPTO's approved, issued patent, use, as his strong reason to get appealed?
Well, so that's a very interesting question, right? So an examiner is a human who does the best job that they can with the time that's allotted to them, and knows only the languages that they know. I don't know any other languages other than American, English, right? So if there is a prior art search reference in Japanese, I might be able to find it if the abstract matches up with the key terms that I searched when I'm searching for foreign references. But if it's a really specific detail, I might miss it. It's a needle in the haystack. But it might be really easy for somebody where that's their native language to discover the piece of prior art. So there are procedures for revealing prior art that come onto the record to the USPTO for cases that have already been allowed. You can file an IDS that says, hey, this search report came out, there's this reference, is my patent still valid with the US government? And you might have, the examiner might say, oh, I didn't see that reference before. I need to, we may need to reopen prosecution and take a look at, in light of this new evidence, this new IDS. So no, you can't say like, I was given a patent in the United States, give me my patent elsewhere. And we do the same thing, right? Oftentimes we'll have, WO, PCT applications, or even foreign filed, it was filed originally in Chinese or Japanese, and then they file in the United States, and there is a search report, and it was given an allowance stamp. Also, just the metrics by which we discover obviousness is different between different patent offices. We like to think that we are the best patent office, and I believe that we have a very strong understanding of obviousness, and we discover a lot of prior art. We also have a lot of prior art that's in English, NPL and patents. And we have a lot of good tools to help discover good prior art as well. But yeah, people have different metrics especially as we get into computers and computer programming. Something that may be allowable in one country is just not allowed in another. We're constantly having a conversation about computer programming language and what is 101 eligibility, and now we're getting into AI, where Australia is, kind of giving the green light that if artificial intelligence creates a new idea that's patentably distinct, then they can file for a patent. But it gets really tricky in the way that our court systems work in the United States. And so, I believe we've come out, our most recent one, there's disclosures about how we're handling AI, or the idea of AI creating and being an innovator, an inventor.
Thank you.
Yeah, hope that helps.
So Tatiana, you maybe mentioned that in our next session or the session after, we'll have something to do with the software applications, right, in this series talk, which is very difficult.
Yes, so thank you. Our next session will be on Monday, October 25th, which will be filing a provisional and non-provisional application. And then on Monday, November 22nd, we'll have patenting apps and software applications. That's what Connie just mentioned. And then session 4 in December will be how to conduct a prior art search. So if there are no further questions, I guess perhaps this is where we say thank you to Stephen very much for your time and your great presentation. and Connie and Mei Ling for your support in organizing all of this, and Dee for your partnership in this webinar series. And thank you everyone for attending.
Oh, can I have one last
Please.
word of goodbye? So yeah, thank you everybody for sticking around. Really great Q&A. That's why I love the live events, is the Q&A. Otherwise, I would just record myself talking and then press play, and then I'd go sit elsewhere, right? So the Q&A really makes it engaging for me to be here. But I also wanted to just say I've always been a patent examiner, and if you're ever interested in that as a field of endeavor for a career, one of the aspects that has been most enjoyable for me is that the work you do is contained to patent examining, and then it gives you a lot of your own time to do what you want. And I will address, you know, the bottle in the room. Yeah, so I do wine education and outreach. And so I say that not to promote myself, but to say that the examination career allows you the opportunity to pursue patents outside of your work that are completely different and oftentimes very artistic or musical in nature, whatever it is that you find passionate, like, you know, that you have your passion in. And so that's my plug for being an examiner. Love my job. And so I'm happy to be here with everybody today to share a little bit about patent information, as well as to those undergrads that are maybe going to be looking for careers at some point after Rutgers. Consider the USPTO.
Sounds great.
I hope that's a good plug. I hope that's an okay plug.
Yes, please. Thank you. And again, if you want to learn more, reach out to us, innovate.rutgers.edu. If you have an invention, innovator portal.rutgers.edu, and feel free to find one of us online, reach out by email. We're always happy to hear from you. Thank you all, and have a great evening.
Thanks so much.
Yeah.
And Stephen, I loved your plug.